This hearing is in the matter of case number CFI 020-2021 before Justice Wayne Martin. The hearing is being held by way of video conference at the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Bird and Bird MEA LLP. Lead counsel is Mr. Stephen Thompson. The defendants are represented by Clifford Chance LLP. Lead counsel is Mr. Alexander Gunning.
Thank you. Now, gentlemen, you're obviously aware of the purpose of this afternoon's hearing. It's just to, if you like, give a bit of a check on preparations for the hearing, which is due to commence on the 7th of June, and to run through a few issues relating to that hearing. I see from the documents that you've filed that you were good enough to resolve an issue that was otherwise going to be heard this afternoon, so I'm grateful to you for that. Well done. Congratulations. Let's hope that spirit persists throughout the hearing. So I'm open. I've of course read the skeletons that you filed for this hearing. I'm happy to address the issues you've raised in any order you like, but I'm open to you, gentlemen. Who'd like to go first?
Well, my lord, good afternoon. Perhaps I should go first. Stephen Thompson for the claim. And Mr. Gunning and I have had discussions this morning via email about what might be left for your lordship to consider this morning, and as you've anticipated, it's very little. It's purely logistics. There are a few things that fall into the category of either confirmations or updates for your lordship, and I'll just run through them, and perhaps we can just take them one by one because they're pretty simple. The first thing is that the registry has indicated, I think back in February, that the trial would be operated remotely, and that is the basis on which the parties have been operating. But we just wanted to triple check that with your lordship.
Yes, that is the position. There has been a policy decision taken by the court to significantly restrict in-person hearings during the course of this year, and so that policy will apply to this hearing. I can tell you that it's expected that policy will change significantly next year, when we will return to a much more normal operating environment, it's hoped. But at least for this year, the presumption is of remote hearings rather than in-person hearings, and so that presumption will apply in this case. And as I understand it, the witnesses are in different places anyway, so it's probably, and counsel might be more convenient for counsel also, rather than trotting out to Dubai. It certainly is more convenient for me. So that will be the way we'll operate.
I'm very grateful. That's a very helpful indication. Council will do as they're told, I'm sure. But you're right about the witnesses and their locations. I think they're strung out between New York and the UAE. Nobody, I think, as far east as your lordship is going to be. That brings me to the question of the sitting hours and indeed the sitting week. I mean, there's obviously been a legislative change in the UAE, or in Dubai at least, about the normal business days, which I don't think the RDC has quite caught up with. Again, Mr. Gunning and I were rather assuming your lordship was going to sit Monday through Friday, but perhaps this is a good time to discuss that.
That assumption. Well, I don't think we're scheduled to start until the Tuesday.
That's right.
The 7th. But I do propose that we sit on the Friday and not sit on the Sunday. Unless anybody has an objection to that course.
No, I don't think anybody does. There's one point which it's possible that one, maybe two of the witnesses might want your lordship's leave to take Friday prayers in that instance, which might take 2.5 hours out of the day in order to get to prayers and so on and so forth. But I mean, as long as your lordship's amenable to that accommodation, and it may not be required, it depends where we are in the timetable, of course.
Absolutely. Well, obviously, we will accommodate those religious practices to the extent we need to, and if we have to sit a little later, I don't think that'll be problematic for you where you are. It'd be more problematic for me if we go a bit later. Yeah, well,
I'm always mindful. I'm always mindful of the court staff, and one doesn't like to inconvenience them in those circumstances as well. But I'm sure we can manage that as things go forward. And the other mechanistic point is the hours. I mean, if your lordship is going to be in Australia, Mr. Gunning and I think various others will be in London. Of course, the case is a DIFC case, so we're rather working, say, on the presumption that we'd be operating on DIFC sitting hours, but I don't know how your lordship.
Well, that means 6 a.m. in the morning for you, doesn't it, gentlemen? starting
I
time?
think it's 7 now. We have daylight saving.
Yes, I'm sorry. Just to be clear, I will be in Dubai, so I won't be in London.
Yeah.
Well,
my lord, I'm in your lordship's hands. I mean, earlier than 6 or 7, it becomes uncomfortable, but clearly not impossible for me.
If 7 a.m. is okay for you, Mr. Thompson, that works well for me because that's 2 p.m. in the afternoon in Perth. So that's a convenient time for me. And if Mr. Gunning's in the UAE, then that should work, I think, for everybody. Now, except of course for the American witnesses, which are going to be problematic.
Yes, and that will probably be, I say this tentatively, but probably be the first witness. So I imagine he would be starting either on Tuesday afternoon or Wednesday morning. Tuesday afternoon wouldn't be a problem, I imagine, for him at least.
But he's on the East Coast.
He's on the East Coast, so that's 5.
What will the time difference be between the East Coast and Dubai? Or
so 8 hours. 8 hours before Dubai,
right?
So 10 a.m. would be a little painful, I imagine.
Yes. All right. Well, that's fine for the first day if we start him in the afternoon. It's not so good for the second day.
To the risk of interrupting, is Malenkov sure that he's going to be giving his evidence from the United States? I'm pretty sure I'd seen somewhere an indication that your witnesses were going to be giving evidence from London.
Let me double check that. That may well be right. Yes, I'm being told that he'll be in London. So I don't think it'll be a difficulty. I think he's going to attend in London. I suspect I've been told primarily for this reason. But so apologies. Yeah,
well, that'll make life a lot easier then.
Yeah. Okay. Good. So we'll operate then on the basis that we're going to start at 10 a.m. every day and run through presumably to about 4 p.m. Gulf Standard Time.
Yeah, with the usual flexibility to finish earlier or later if required to finish a witness.
Well, I'm very grateful. The only other thing we want to check with you, I think, on timetabling was there is built into the, I think, case management order, a day and a half for your lordship to pre-read, which we anticipated your lordship would be able to do prior to the 7th of June. I hope that's been...
Yes, that is a very safe assumption. So we will kick off the hearing on the 7th of June. I understand from the timetable that you've agreed the bundle will be complete by the 2nd of June.
Earlier, I hope. Yes.
Okay. All right. Well, anyway, so long as I've got the documents 4 or 5 days before the hearing, I'll be able to immerse myself in them. We have a long weekend where I am in the period preceding the commencement of the hearing, so that'll be just perfect for me to interrupt my long weekend by reading a long bundle. So that'll be great.
Yeah, so do we. Excellent. Well, I think the timetable which Malone Friends helpfully set out in his skeleton argument anticipates that you should have all the relevant documents, including the skeleton arguments, by the 2nd of June. It's in E7. That's the second page of Malone Friends' skeleton argument. He's extracted that from the case management order, but it's yes. Helpfully calculated with particular days. I think there's only one other thing I wanted to raise with you about the timetable of the trial. As ever with these things, as your lordship will appreciate, sometimes witnesses go longer and shorter than expected. I've raised this, I think it's been raised in correspondence, that the timetable might seek to ensure that all the witnesses are available the day or before they're scheduled, the day or after, so that if they do overrun or go short, matters can be kept ticking over. I'm sure Mr. Gunning will agree that will be useful to ensure your lordship isn't left twiddling his thumbs or sitting late on days.
Well, nothing is calculated to enrage a judge more than lost time during a hearing, Mr. Thompson. So I just mentioned that. It's not in terrorem, but I just mentioned that. So it would be convenient if the witnesses could make themselves available to be called if we do move, as we hope, move faster than expected.
That's useful to know. I thought it was counsel taking longer than their time estimates, which then enraged judges the most.
Oh, well, that's another good way of doing it.
We'll see how many boxes we can tick during the trial. I mean, otherwise, I think we're all on track, my lord. I think my friend and his solicitors were contemplating instruct or engaging live transcript writers. I've been speaking to my instructing solicitors about that overnight, and we're not at all convinced that it's necessary, but that's obviously not for us to stop Mr. Gunning and his clients if that's what they wish to spend the money on. It may be, and it's he'll address you on it, that he needs your permission for that. I don't have any objection if that is the case, subject to your lordship. And the very last point was, I think my friend wanted to raise was whether there might be an opportunity for written closing submissions, but in my view, that's something that can be dealt with at the appropriate time, halfway through or at the end of the trial.
Yes, all right. Well, thank you for that, Mr. Thompson. Mr. Gunning, over to you.
Very little to add, really. I think we are all agreed on the pre-trial timetable as set out in our skeleton argument, and which in any event is required by the existing case management order. I think the two points that remain to be mentioned by me were firstly the one in relation to transcript. There's obviously going to be quite a lot of oral evidence in this case over a number of days, and we think it would be appropriate for there to be a transcript, and ideally a live transcript of that evidence. So far as the question of whether permission is
there, there should be a transcript, obviously. The question of whether it should be a live transcript is, I think, essentially one for the parties rather than for me, because it's obviously of much more assistance to counsel than it is to a judge.
Sure.
If the parties are disagreed, then my tentative view, if you need permission, I'm happy to give it. But my view would be that if one party doesn't want live transcript and the other does, then the party requesting live transcript would have to pay the differential between ordinary transcript and live transcript. Okay. That's my view on that subject.
Okay, understood. I mean, so far as the question of permission is concerned, I think the way that it works is that Rule 35.99 says that no party or member of the public may use unofficial recording equipment in any court without the permission of the court. And so that's the issue. What I suggest is we come back to this at the beginning of the hearing, because there's no point in you granting permission generally. It ought to be specific to whoever it is that's using the recording equipment. But I anticipate
it has its own transcription providers who are Epic. I would imagine that your instructors could contact Epic and find out what the differential is and make an arrangement with them.
Yeah. Okay. Fine. I apologise if I look as though this has taken me slightly by surprise, but I had understood actually that the claimant solicitors had volunteered to get those quotes, and so in their letter to us, which is in the case management bundle. But I don't think this is a major issue, and we can come back to it in due course. But that does remain our preference. The only other question was in relation to written closing submissions. There's nothing to say about that. I mean, the point is that Rule 35.73 has provision in it for that question to really be revisited as we get closer to the hearing. And so what I suggest we do is we liaise on that topic, possibly even on day one of the hearing, to work out how best we're going to deal with it.
What I don't want is for us to fall, let's say things go well and we finish the evidentiary portion of the hearing much earlier than we anticipated. And then I say, well, wouldn't this be a good opportunity for you to, if you've got a spare day, go and prepare and we'll have oral closings, and then be confronted by counsel saying, oh no, that takes us completely by surprise. We had contemplated written closings. So long as both counsel are alive to the possibility that we might do oral submissions and ready for that possibility, I'm very relaxed to leave it until we get to the hearing.
Yeah. I think that was the base upon which we were proceeding. I think Rule 35.73 says in a more substantial trial, the court will normally also require closing submissions in writing after oral closing submissions. So any hope that my learned friend and I might have had that we could put you off having oral closing submissions in the hope that we could defer it until after written closings is pretty vain, I think. So
we'll just play that by ear in light of, I mean, it depends obviously on the nature of the evidence. If there's a lot of detail that needs detailed revision, then that makes a stronger case for written closings, because I will be assisted by your review of that detail. But if, on the other hand, things go pretty much as expected in the course of the openings, then there's a lot to be said for getting on with it. and finishing it. But we'll just play that by ear as we go along.
Agreed.
Is there anything else?
No, I think apart from that, there's nothing else. And I think given that the pre-existing timetable arises out of the existing case management order, there's no need for any PCR order as such.
Excellent.
Excellent. And you will obviously be you'll be getting materials from us over the course of the next few weeks, including, I think, most importantly, that agreed timetable, which will come on the 2nd of June.
Yes, good. Well, gentlemen, I'm sure there are a lot of people watching this call, sitting behind you, metaphorically, who've done a lot of work to make sure we get to this stage. So I'm very grateful to them for having complied with all the court's directions in a timely fashion and getting us to the point where there is so little to talk about this afternoon. So well done to all of those involved in reaching that point. And well done to the parties for resolving the issue that was going to be determined today. And as I say, let's hope that spirit of cooperation prevails. I see no reason why it won't. And I look forward to hearing from you in writing between now and the 7th, and to seeing everybody on the 7th of June. If there any issues arise in the meantime, you know where to find me.
My Lord, I'm very grateful. I think probably the only order which you might want to make today is for cost of this hearing to be in the case. But yes. That's yes. I can't think of anything else substantial.
Right, I'll do that.
I'm grateful.
If there's anything else, gentlemen, thank you to you and all who sit behind you metaphorically. And as I say, we'll resume on the 7th. It's now adjourned.
Thank you.